May it please the court. This case on appeal presents 5 issues that warrant reversal by this court. My arguments today are going to focus primarily on 3 of those issues. First, the district court erred in denying remand in this case because the security agreement executed between Salt and Light and Origin Bank contained a forum selection provision granting the parties a first mover's right. Once, as Salt and Light, as the plaintiff in this case, exercised that right, it set the forum for the dispute between the parties in the appropriate court of jurisdiction within Dallas County. After that decision, Origin waived its objections to venue and personal jurisdiction in that specific forum selected by Salt and Light. Under this court's holding in the 2000 decision in Waters, recognizing that choice in your counterparty to select the venue and the forum for those claims to be brought in vitiates the right of the defendant to remove to federal court. And under this court's 2022 decision in Dynamic, that creates an interpretive framework and the understanding for parties contracting for forum selection that the phrase brought before a particular jurisdiction means maintained in that jurisdiction and decided by that jurisdiction. Remand in this case was appropriate.
Do you say that the most recent opinion, Gulf Coast Pharmaceuticals, misreads and is therefore incorrect and not binding on those precedents you just named? It does seem to me Gulf Coast Pharmaceuticals is closer to your contractual provision than Waters, or I'm not sure about Dynamic. So what's your take on Gulf Coast?
Well, Gulf Coast dealt with a provision substantially different than the one here, but only because it lacked that opening clause to these parties' forum selection clause. That, namely, is a claim or suit arising out of this agreement may be brought in a court of appropriate jurisdiction in Dallas County. That language was absent from Gulf Coast. And the decision there focused in on the language in that venue provision, which focused exclusively on venue. And it allowed the parties to choose between multiple forums within Harrison County in which their cases would be heard, meaning that it wasn't exclusive of any other court. Here, we don't have that plural language of forums or courts. It is a choice of a particular court of appropriate jurisdiction in Dallas County, which Salt and Light, as the first moving party and plaintiff in this case, selected as the 134th District Court. On top of that, the second clause of that provision, the bottom sentence as it's presented in both briefs, says that the second party, or the defendant in this case, Origin, waives its objections to venue and to personal jurisdiction in such forums, separate and apart from Gulf Coast, which said that those objections were waived in forums. So those 2 distinctions alone, I think, separate this case from Gulf Coast. It is relied upon as part of the split between district courts within this court's jurisdiction.
I guess I see the first filer point as an agreement as to a court of appropriate jurisdiction in the county. But I'm sort of stuck at that point thinking, well, this is an appropriate court in that venue.
And that's correct, Your Honor. I mean, it is
the district court was.
The district court is a court of appropriate jurisdiction, but Your Honor's reading of that clause would just cut out 2 words. That is, brought in an appropriate court of jurisdiction. And as this court held in Dynamic, that language has significant meaning, especially in the context of forum selection clause. It means not only that a claim is initiated or started or commenced in that jurisdiction, but it is maintained in that jurisdiction, and it waives the right of removal, which is precisely that holding of that case and was relied upon.
Which case is that?
That is Dynamic CRM Recruiting Services. It was this court's 2022 opinion written by Judge Willett. And that was relied upon just a year later by the Texas Supreme Court, who is, as the parties agree here, the final say on interpreting contract language and discerning the intention of the parties under Texas law. In a case titled Brown against City of Houston, decided in 2023, the Texas Supreme Court looked to this court's decision in Dynamic, looking at what this court held brought before a jurisdiction meant, and applied it to the statutory context, saying in some legal context, particularly in forum selection clauses, that specific language has meaning to the contracting parties, and in Brown, it's statute. And they said that that means the exact same thing under this compensation statute for particular criminal defendants, as it did in Dynamic against CRM. But going back to the context of a forum selection clause, the Northern District, just a few months after the Brown v. City of Houston case, I believe, in 2023 addressed a similar form selection clause, applying dynamic, found that language filed in a particular court, not brought before, brought in, as is the issue here, but filed in that particular court meant that the claim had to be maintained there.
So you say the such forum in the waiver clause has to refer to the brought-in court.
That's correct, Your Honor.
Is that clear and unequivocal? I would think the natural reading would be that such forum refers to a court in the jurisdiction of Dallas County.
Well, so that the permissive language in the first clause, Your Honor, gave the choice. And so we can't forget that the clause allowed both parties the option as the first filer to have that advantage of selecting the particular court. And that's what the objection to that specific forum instead of forums means. After that choice was made, it would be mandatory, under Waters, which recognizes the first filer's advantage in this context, and under dynamic. And I think that kind of difference between forums and venue was part of the Gulf Coast opinion. And Judge Ho actually pointed out the definitional differences between those two words. But he held specifically that the term venue in the provision could reasonably refer to the geographic venue for the lawsuit. In other words, it could have had two meanings. I would invite the court's attention to the language in this clause, which the opening sentence refers to both a court and Dallas County, two different things. A court is a jurisdiction, and the venue in Dallas County, the objection in such a forum relate to a court and not to Dallas County. Once Salt and Light initiated this cause of action in the 134th District Court, the right to removal in origin was waived. And that's the same.
Just because of time, whichever court you're in, and let's assume we decide it's our court, federal court, could you move to the business disparagement and just tell me where was anything false communicated? And you know the three big issues. False, where was malice suggested, what evidence of malice, and where's the proof of foreseeability?
Taking those in reverse order.
No, maybe take them in that first order.
Absolutely, Your Honor.
What's the false communication?
The false communications and statements related to Salt and Light's ability to cover its debts or to go into default with origin. Now, there are three particular communications at issue. The appellees contend that there's only one. Their brief only addresses a notice sent out to every one of Salt and Light's customers. There's more than that, and there's more than that in relation to ProPetro, Salt and Light's largest customer. They not only sent that letter to ProPetro saying that Salt and Light was going to default, couldn't pay its bills, and that there was going to be an enforcement action to collect against its customers, but there was also telephone communications and emails that are referenced in the recordings of ProPetro conversations that are reflected in the Hernandez affidavit at ROA 6451. Those communications included additional content and additional allegations against Salt and Light that, as ProPetro framed it in their own words, caused them to run away from their relationship with Salt.
But they were already in discussions about terminating that relationship. I mean, is that in dispute?
That is in dispute, and it's heavily in dispute, Your Honor. For the reasons that the district court improperly weighed evidence on this foreseeability issue, particularly as it relates to a cause and fact analysis, they assumed without evidence that the plan to phase out, as the district court called it, Salt and Light's relationship with ProPetro had actually occurred. The phase-out plan, was to bring that work in-house at ProPetro specifically, and as of at least June 14th, 2023, seen in the Hernandez affidavit, and there's no reason to believe this isn't still true today, ProPetro never brought that work in-house. They hired a different contractor, a competitor to Salt and Light. I mean, it just never happened.
But does that matter? If they had discussions about bringing that work in-house and it just so happens to not have occurred, why does that matter? Why is that relevant?
Well,
that doesn't mean that they weren't already having those discussions.
And whether they had those discussions is separate and apart from whether they acted on it. If they were going to have the discussions to bring it in-house, and those discussions happened, I mean, as a fact, it just didn't occur. They didn't do it, and there's no reason to believe they would have done it, and especially when considering they went to a different contractor altogether. The plan was abandoned. But separately, that is an issue of material fact that was construed against Salt and Light in this case, and should have been in a light more favorable to Salt and Light as the non-movement on summary judgment. And so that is a material issue, an issue of material fact, but the district court ignored. It ignored the evidence we brought to counter that evidence, particularly contemporaneous recorded conversations of pro petro.
What is your argument that those would have been admissible at trial?
Well, they would have been admissible at trial under a host of different circumstances, not the least of which would have been calling Mr. Hernandez, who is not only present for those conversations, but he was the one who recorded them. And additionally, Origin. And
So as impeachment, if his testimony was contrary to what was on the recording, is that what you mean?
Well, so if, for example, the Origin were to rely on those statements as they do in their briefing, they did in summary judgment below, they rely on sworn deposition testimony from pro petro that they terminated their agreement for issues other than what Origin told pro petro. Now, they have to rely on that evidence in order to succeed and disprove an element of foreseeability and causation, as Your Honor pointed out earlier. Relying on that evidence in and of itself requires us to bring forward that prior inconsistent statement as directly on point, but I don't think that it can only come up, Your Honor, in the context of a rebuttal or a prior inconsistent statement. I think Mr. Hernandez could introduce his evidence independently for the reasons why pro petro actually terminated its relationship with Salt and Light, which wasn't the plan that was stated in the briefing or later given. And during the time that those sworn statements Origin relies on that we disagree with, pro petro was in an active lawsuit with Salt and Light. They were adversaries in a different proceeding that was resolved out of court.
I guess, step back. You're saying Origin was the one that disparaged.
That's correct,
And
Your Honor.
you're going to get to malice, because it's difficult for me to see where malice was shown, particularly if Origin had given 8 or 9 extensions already. Is that correct?
I believe that's correct, Your Honor. I don't have the exact figure.
So Origin's 8 or 9 extensions, but their vested interest would be in not having the business relationship be severed, correct? Because they want to continue to recoup their money.
Well, they were going...
So what's the logic of malice? And where's the evidence of malice?
That comes from the Amerisource relationship, Your Honor, and I agree that they want to recoup their funds, but that was already in process. We were at this point in time when these letters and phone calls and email communications to pro petro were sent, days away from Amerisource funding an agreement to take Origin out of this relationship. They were clearly exiting. This relationship was not going to continue between Salt and Light and Origin. It was on top of that Amerisource action, which is not hypothetical. I mean, they funded this transaction. There was an agreement between the parties reached that resulted in Origin dismissing a filed lawsuit that it maintained against Salt and Light because Amerisource was stepping in to take that relationship. So looking at Your Honor's direct question about malice, the intentionality and the level of culpability, for example, to use a frame of Origin, exists in the circumstances surrounding when they took that act. To Your Honor's point, 8 or 9 extensions. They maybe grew tired of doing business with Salt and Light, but they intentionally acted upon, effectively the eve of Amerisource buying them out to send these letters and then later to retract them away from all of their customers, each and every one of Salt and Light, and then targeted pro petro.
That deal, am I correct that deal hadn't taken place at the time that you originally told Origin that it would take place? Like, was it later than the date that you had given them for that to be sort of?
I think that's correct, Your Honor. There was a lot of work out happening, and it happened over a period of time. I don't think there's any dispute in the record that Salt and Light had been dragging on the process and that Origin became tired of the wait to get themselves out of that original relationship with Salt and Light that had gone on for years, but was currently floundering. And I don't want to miss Your Honor's question about the falsity of the statements. I mean, now, the fact that they retracted them I don't think establishes falsity, but the facts that Your Honor and I were just discussing in response to your malice question, I think are the exact facts that were ignored or just construed against the non-movement Salt and Light on the summary judgment record. The court weighed in on the credibility determinations of those evidence. It decided that the deposition testimony given by a litigation adversary to Salt and Light, who didn't know at the time Salt and Light possessed those recordings, was more credible than the contemporaneous statements. It decided that the frustration of Origin's business relationship with Salt and Light deserved more weight and credibility than the agreement that they reached that resulted in them dismissing a lawsuit and a balance on all of the sheets at Origin showing 0. And there's no dispute in the record that their accounting shows $0 owed from Salt and Light at the time of these actions on the basis of Amerisource.
Just a few seconds on the UCC claim. You're saying the letter was commercially unreasonable, even though the security agreement said they could send those letters?
We're saying that the letter, the phone calls, and the emails were, it's the combination in each individually unreasonable because they were not taken in good faith under the statute. That is a violation of the UCC for which section 9.625B provides compensation.
Well, what's the contract that was breached?
There's no breach of contract alleged, Your Honor, in this case. The breach of contract is in the cases that rely on those holdings are actually cited by the appellees, and we disagree that they're applicable in this instance because 9.625B provides compensation to a plaintiff for any loss occasioned by violation of Chapter 9 of the UCC, which is the exact kind of explicit language the UCC instructs us to look for when setting aside the general rule that certain damages are not available under the UCC. I see that my time has run out. I'll reserve the rest for rebuttal, unless there are any other questions.
Thank you. Well, as you say, hear from you again.
May it please the court, Griffin Rubin on behalf of Origin Bank, appellee. Your Honors, I'd like to pick up on the venue selection clause issue that Your Honors were interested in. There is a crucial difference, and the problem for Salt and Light is the plain language of the text. Under the provision, it states that claims may be brought in a court in Dallas County, Texas, and the party's objections to venue and personal jurisdiction in such form are waived. This language is clear and unambiguous, just not the way Salt and Light would like it to be.
Counsel, it does seem to me, even if you're right on that, the point has some purchase to it, that there's a shift in the second sentence. I guess it's only 2 sentences in the whole thing. That objections to venue and personal jurisdiction in such form, which seems to me could be read as opposing counsel says, that once that form is selected, objections to it are waived. It's a form or the form or such form.
In such form, yes, Your Honor. So 2 responses to that. First, what their argument primarily ignores are cases like Alliance Health from 2008, in which this court said when a clause states in insert county here, there's a single part test that comes next to determine if there's been a waiver of removal rights. And that is there a federal courthouse in that county? Obviously here the answer is yes, but that is a fact that is very inconvenient for the other side. But to more directly answer your question, Your Honor, even if their argument has mild purchase, just as Judge Higginson touched on a moment ago, that would mean that it's not clear and unequivocal, which is the standard in this court for waiver of removal rights. There are 3 possible outcomes. There's clear and unequivocal in Salt and Light's favor, clear and unequivocal for Origin Bank, and ambiguous. Under the latter 2, Origin wins. And that's why we win on that issue here, Your Honor.
And the various cases that make the constellation, you would say Gulf Coast is your strongest?
Gulf Coast, Your Honor, I would say is the strongest for the ambiguity proposition, that to the extent that there's any ambiguity, which Origin does not concede in the slightest, then there would be ambiguity, and therefore Judge Godby's order would still be correct. I would say our best in terms of just analyzing the textual language of the clause is probably Alliance Health in terms of the insert county here. And if for nothing else, as we noted in a footnote, there's been a well-documented law review article from the Review of Litigation in which a well-esteemed appellate partner at the firm representing Salt and Light actually agrees with Origin Bank's position. So we'd want to turn the court's attention to that as well. Further, Your Honors, unless there are other questions about the waiver of removal rights, we think that issue is fairly clear. Judge Godby was correct in deciding so. Turning a moment to the business disparagement point that Judge Higginson was asking my friend on the other side about. You're correct, Your Honor. There is nothing in the summary judgment record that goes to the arguments that they make. 0. There is nothing about actual malice. They have no record evidence that anything that was said was false. And so that right there is an independent point on which Judge Godby's order could be affirmed. Additionally,
But let's say we're just sticking with Judge Godby's actual reasoning.
Well, I wouldn't want to go against someone like Judge Godfrey, but yes, Your Honor, we can make those
So he
arguments.
faulted it on lack of foreseeability, which walks into the recordings.
Absolutely.
But he didn't say they're not competent summary judgment evidence. So he didn't, I mean, he left it open.
Yes, he left the admissibility issues open, but what he didn't leave open is what he thought of the recordings themselves. It's 5.5 minutes, jumbled together, snippets of triple hearsay, what have you. But what Judge Godfrey said was, even if it were admissible, it's non-probative.
But it does impeach Foster, right? It sounds like in the recordings, he's being pretty blunt that there's a catalyst here, which is the lack of funding, and that's going to speed up the need to run away from them.
Respectfully, Your Honor, I would disagree.
Okay.
And the reason being, actually read in its entirety, the recordings don't demonstrate that any decision was made by Pro Petro at that meeting. All that was had was a discussion. After we finish here today, Your Honors are going to go back in that room and talk about these cases. That doesn't mean that whatever was said during that conference is the final decision. And so even just discussing what are the options on the table, that's all the recordings stand for. So
Why does it need to be the final decision? It seems to me that if what occurred prompted Pro Petro to consider accelerating their separation or even causing them to separate from Salt and Light, it does seem to me that what happened thereafter is at least fair, there's some circumstantial evidence from those recordings that it did start the decision-making to separate themselves from Salt and Light.
Well, Your Honor.
So the decision wasn't made there, but I don't see why that matters.
Well, respectfully, Your Honor, in weight of the evidence that is actually in the summary judgment record, I would respectfully disagree.
Well, you said weight of evidence. We don't deal with weight of
I
evidence
apologize,
in
Your
summary
Honor.
judgment. You want to rephrase?
I would really appreciate that, Your Honor. Given the evidence in the summary judgment record, it is simply uncontroverted that there was a plan instituted by Pro Petro months before the origin notice letter ever was sent or received. And then there are emails, from Pro Petro to Salt and Light beginning to discuss the problems that actually led to the termination of Salt and Light and their relationship with Pro Petro, which were problems with cost and problems with quality of service. From there, the phase-out begins to occur in May 2021, begins to be implemented prior to the notice letters being sent. At some time after the letter was received by the accountant, by Pro Petro, we don't know exactly when, even though there are statements in the briefs that say otherwise. We don't know when in August, but at some point after the letters are received, Pro Petro has a meeting internally to discuss, among other things, the letter. But as the unequivocal testimony, unrebutted testimony of 5 people with personal knowledge demonstrates and shows, and it's all in the record before this court, it was simply a conversation. It was a discussion, and at the end of the discussion, it was said, okay, we are proceeding with the plan as we set it out in May of 2021. And just to be clear, in that email, in that letter, implementing the plan in May of 2021, there was a specific target date, Q1 of 2022, for the full phase-out of Salt and Light as a vendor for Pro Petro. And sure enough, what does the unrefuted, unrebutted, substantial evidence show in this record? That is exactly when it occurred. And
So your friends on the other side said that because it never came to pass, you bringing that work in-house, that we should disregard that.
Your Honor, respectfully to my colleagues on the other side, that's a red herring. There were 2 aims, and the primary aim was to release Pro Petro, to terminate the relationship with Pro Petro. That plan was set out in May of 2021, and it was consummated and completed just as designed in Q1 of 2022. The issue about bringing in-house, they're absolutely right. Up to that point, it did not end up happening. But again, it's a red herring. What did happen is that Pro Petro was phased out. Period. End of story. Judge Douglas, you were also mentioning earlier that when it came to the termination plan, and said, well, it's not really in dispute that there was a plan, right? There had been talks before, prior to the notice letter coming in. That's not in dispute, is it? And my friend on the other side said, oh, Your Honor, it's heavily in dispute. Again, that runs into the same problem that Salt and Light faces throughout this case and throughout this appeal. They don't have record evidence for that proposition. It's merely arguments of counsel. They cannot come back up here and point to a site in the record anywhere that backs up that fact. And Your Honor, and Judge Higginson, you also touched upon the letter and its timing in regard to the UCC plan. I wanted to touch on that for just a moment because I was surprised to hear my friend on the other side when asked, oh, was it just a letter? And he said no and added a couple of things. So it was the emails, it was the conversations. To my knowledge, that is the first time that argument has ever been made. I may be wrong, but I'm fairly confident that is the first time that argument has ever been made, so I just wanted to point that out for the court. At day's end, Your Honors, what we have here is a summary judgment record that leads to only one conclusion. No reasonable juror could find otherwise. As the district court held, Origin submitted, quote, substantial, unrefuted, summary judgment evidence establishing that ProPetro already had a plan in place to terminate Salt and Light and took steps toward that plan long before ProPetro received Origin's notice letter, end quote. Uncontroverted record evidence demonstrates that in May 2021, months before it received Origin's notice letter, ProPetro implemented a plan to phase out Salt and Light in Q1 of 2022 because of cost and quality of services issues. Contemporaneous documentary evidence shows ProPetro began executing that phase-out plan in the weeks and months before receiving Origin's notice letter. Additional documents, as well as the testimony of those 5 previously mentioned individuals with personal knowledge, confirm that ProPetro did not alter the phase-out plan after receiving Origin's notice letter. And Salt and Light terminated its relationship with ProPetro in February of 2022, which marked the successful completion of its May 2021 plan to phase out Salt and Light at that time. This substantial, unrefuted summary judgment evidence, particularly when compared to the utter absence of summary judgment to the contrary from Salt and Light, who is the party with the burden of proof at trial, clearly demonstrates that no genuine issue of material fact exists on the causation element, which warrants affirmance on that issue. I see I still have time left. I'm happy to continue on with my remarks, but obviously I want to make sure it's the court's time. I want to answer your questions if you have any.
Hearing none, we appreciate your argument.
Thank you, Your Honor, and for all those reasons and the reasons in our briefing, we respectfully request that this court affirm the district court's judgment. Thank you.
Judge Douglas, during my initial argument, you asked me about whether or not the reason for termination mattered, and I said that it did for the reason that the facts in dispute about that termination are why summary judgment, without sending this issue to the jury, was why that reason for termination mattered. And on that same point, my colleague on the other side said that he was unaware of the telephone and email communications being raised in this issue prior. On that point, I would point the court to pages 5 through 7 of our opening brief, which explicitly on the top line of page 6 says emails and telephone, I believe. And then in our reply brief on page 20, to those fact issues you and I discussed, Judge Douglas, we go point by point in response to the same argument we heard today that was in the appellee's brief that there is no evidence in the record. Taking the statement given in testimony, which is where the plan comes from in deposition testimony, and then putting immediately underneath it the quote from the recorded contemporaneous and prior existing statements from ProPetro that refute those claims, and that goes from pages 19 through 21, all of which explain why summary judgment on the causation issue was inappropriate.
Since you're talking about your brief, in their brief they state that your brief misquoted international shortstop. So in the first paragraph of the portion of your brief that says the district court misapplied the law of causation, you say, quoting our court as your first authority, that the actual rule that the district court misapplied is that the disparagement played any part more than a scintilla. in quotes. And their brief says those quotes don't exist. I didn't find them.
And so I don't know what footnote number it is, Your Honor.
It's not a footnote, it's in your first paragraph and your first authority.
Excuse me, the appellees are correct about that quote being incorrect. In our footnote, in our reply brief, we addressed that and actually retracted those quotes with parentheticals. We did not retract our reliance on that case for the appropriate reason it was cited. We investigated why it ended up being cited there, and it was just a simple plain error from counsel and didn't have any other explanation in the version history. But that footnote in the reply brief retracted, I think, 2 of those quotations from International Shortstop, maintaining that it stands for the proposition weighing motives on summary judgment is inappropriate for the district court. But Judge Higginson...
How did the quotes show up?
They're parentheticals, or I think hanging quotes that were created by the drafter of the brief, and I believe that either a copy...
Because that's a central point. If it's not a substantial factor, it's just a factor.
I'm sorry, could you repeat Your Honor's question on substantial factor?
Your assertion of the proposition for why the district court erred was that the test here isn't that it's a substantial factor, it's just a factor. So that's a decisive, crucial quote that doesn't exist.
Well, allow me to clarify then, to the extent that we haven't fully retracted that position in our reply brief. The standard for foreseeability that was in the district court's order below doesn't exist in the cases that the district court cites for that proposition. The district court concludes in a sentence that foreseeability is required under Texas law for this claim, but the Halbert case and Forbes case, as well as I believe the Astoria Industries case that it relies on, don't say the word foreseeability. Halbert, at least, as I can represent today to the court, says that it's a substantial part of that the statement is a substantial part, the alleged conduct is a substantial part of the injury that is caused to the plaintiff. It doesn't say foreseeability anywhere in that analysis, and the district court, in one conclusory sentence, says I decide that this analysis requires foreseeability. But returning to Your Honor's question earlier about falsity and malice in the record, the district court order doesn't pass on those issues. Those issues were not part of its ruling on summary judgment, which related to the foreseeability analysis.
Does that matter? This is de novo review of summary judgment, so we consider what is filed in the same way that the district court did and can rule on any other basis.
I think for the purposes of adequate consideration in front of this court, we would urge, and we do in our reply brief, that you follow the general rule set out in PHH Mortgage Corporation from 2023, where generally this court refrains from passing upon issues that weren't decided in the lower court, and that would also include the admissibility of the recording evidence that the court assumed for purposes of its analysis were admissible. And with my time running out, I would finish with just one note that the district court's order on the venue and forum clause provision relied on the appropriate jurisdiction argument as reserving objections for origin to that court of appropriate jurisdiction. In footnote 53 to their brief, they concede that a court of appropriate jurisdiction in Dallas County does not reserve in them any right to object to jurisdiction later. Thank you.
All right. Thanks to both counsel for your presentations this afternoon. That resolves the arguments for this